to discuss. I want to begin by welcoming our viewers who are joining us on television from West Coast Berbice, region number 5. Welcome. And to our viewers who are also joining us on television from region number 6, New Amsterdam, the east bank of the Berbice River, Kanji, and along the Quarantine Coast, all the way to Orial and Siparuta. Welcome to another program of Issues in the News. To our listeners and viewers who are joining us from Freedom Radio, Rob Street, Georgetown, welcome to another program of Issues in the News. And last but not least, to the thousands of you who are joining us on Facebook Live, right across the length and breadth of Guyana, the Caribbean, North America, Europe, Asia, and beyond. Welcome to another program of Issues in the News. And I want to recognize that I have been away for some time, and I am now back, and hopefully I will be with you from now on as far as possible every Tuesday evening. The reason for my absence, it began with national debates in the presentation of the 2025 budget in the National Assembly. And then, as you may recognize, we have a new studio. I built a new and modern studio so that the transmission and the quality of the transmission would be appreciably of a superior quality. So if you look at the images and you see anything different, well, that is why we were not functioning. I was awaiting the completion of the studio. But all of that now is completed, and I hope you appreciate the new ambience and the new environment. It's very comfortable, and I'm told that the cameras and the mic is working very well. I want to, as I normally would do, invite you to share the program to all your friends and all your followers so that they can join us in tonight's discussion. The wider the audience, the better. I want to welcome Lorraine Ramdihal, Geeta, Prasad, Betty, Chris, Pam Maraj, PM Singh, RM Singh, Rani Bipat Prasad, Sash Gokul, John Robinson, Rabindra Prasad, Lorraine Ramdihal, and all of you. Welcome, 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 and share the program. Use the comment section to express your views, ask questions, pose issues that you may wish for us to discuss. If I don't get an opportunity to discuss it now or today or tonight, I will discuss it at the earliest next opportunity. I want to take this opportunity to extend Ramadan greetings once again to our Muslim brothers and sisters who are observing this great holy month, and we are concluding this month of fasting and prayers. We will soon begin Nawrat. During the course of this week, I think Nawrat, 9 nights of prayers to Mother Durga, will commence from Thursday, and there our Hindu community will go into prayers and fasting, and of course we will be celebrating Easter early next month, within the next 2 weeks from now. And I'll speak about these religious differences, diversities, celebrations, and this cultural admixture at a later point in the program. I have a lot to say about that. But I want to begin by discussing with you a ruling that was handed down by the Guyana Court of Appeal today in an appeal filed by the opposition leader, Azruddin Mohammed, and his father. You would recall that They filed proceedings in the High Court, more than one proceedings, but in this case they filed these proceedings in the High Court, in which they named Minister Onesh Waldron, the Attorney General, and Chief Magistrate Judy Latchman as the respondents. The essence of the claim in the High Court was that Onesh Waldron, the minister, is biased, the Attorney General is biased, the President is biased, the Vice President is biased, and indeed the entire government of Guyana is biased, and therefore the authority to proceed, which was the trigger that starts the extradition process in the magistrate's court, issued under the hand of the minister, was defective because of this comprehensive and embracing bias of which the minister was part. And the bias stems, according to them, from the fact that Azuddin Mohammed is in politics and is the political rival of the government of the day, and that because of that political rival, the government of the day is persecuting him, and this bias infects the entire extradition process, and therefore the extradition process must be quashed. The father claims that he equally is affected because he is a sponsor of the Win Party, of which Azuddin Mohammed is the leader, and he's a financer and a supporter. So because of that, he claims also that he's affected by the bias of the government, and this bias, as they claim, stems from the political rivalry between the government and the Win Party. The High Court, as you know, throughout the case, dismissed the case and ordered the Mohammeds to pay $500,000 cost to each respondent. So that's $1.5 million they were ordered to pay. They filed an appeal to the Court of Appeal of Guyana against the decision of the Chief Justice in that case. And they also asked, as they did in the High Court, for a stay of the magistrate's court proceedings until the hearing and determination of that appeal. The stay was refused, as you know, and I reported to you that the stay was refused earlier when the appeal was being heard, and the court took, I believe, 7 days to deliver its decision. The court delivered the decision today at 2 p.m. I have a copy of the written judgment of the court. It is 29 pages in length, very elaborate judgment of the court, and it is a unanimous decision of the court. The court comprised of the Honorable Madam Justice Roxanne George, Acting Chancellor of the Judiciary, the Honorable Mr. Justice Rishi Prasad, Justice of Appeal, and the Honorable Mr. Justice Nareshwar Harnanan, Justice of Appeal. And as I said, the decision of the Court of Appeal in this matter was or is unanimous, meaning all 3 judges have agreed to the judgment that was delivered. And I want to walk you through a summary of the judgment so that you have an appreciation of the proceedings, because the proceedings are widely followed in Guyana and outside of Guyana, in particular in the Guyanese diaspora. So the judgment began this way, and the very first paragraph of the judgment is instructive, and I want to read it for you. It says this: Nazar Mohammed and his son Azruddin Mohammed, the leader of the opposition, are the subject of a formal extradition request submitted by the United States government in October 2025 to the government of Guyana. On receipt of that request, the Minister of Home Affairs did what the Fugitive Offenders Act, Chapter 1004, requires. She issued an authority to proceed, directing the matter to the magistrate's court, and warrants followed. The appellants were arrested, granted bail, and the proceedings commenced before Principal Magistrate Judy Latchman. That's the first paragraph of the judgment. I pause there to say to you that here it is, the Court of Appeal of Guyana is asserting as a fact in their narrative that Guyana received an extradition request from the government of the United States of America for Nazar Mohammed and Azruddin Mohammed to be extradited to the United States. There's a statement of fact in the first paragraph of the judgment of the Court of Appeal of Guyana. In many affidavits sworn by Nazar Mohammed and Azruddin Mohammed in these proceedings and in related proceedings in the High Court, they have said under oath that they are the subject of an extradition request from the United States to the government of Guyana. They have said so under oath in the High Court, in several proceedings, and in the Court of Appeal. And over the past 3 days, you would have read in the newspapers that the defense in the magistrate court proceedings is pursuing a line of questioning, and they have said to the press, they're pursuing a line of questioning to establish that the government of Guyana fabricated this extradition request, that it did not come from America, that the extradition bundle was concocted and manufactured by the government of Guyana as part of its persecution of the Mohammeds. That is what the lawyers have said to you through the press in their post-court press engagements. They have said to you that that's what they're trying to establish in the magistrate's court, that this extradition request never came from America, that it was hatched in Guyana by the Guyana government, and all the documents were fabricated by the Guyana government in an attempt to persecute the Mohammeds. And here it is, in a written judgment, the Court of Appeal is saying, as a matter of course, as a part of the narrative, as part of the facts of the case, that this request for extradition came from the U.S. to the government of Guyana on the 20th of October for the Mohammeds. And of course you would recall that the U.S. ambassador spoke publicly and said that the U.S. government has made this request and is very interested in pursuing that request. Yet you have in the magistrate's court the lawyers for the Mohammeds telling you, the people of Guyana, and asking questions in the magistrate's court to establish that this entire extradition process is a fabrication. I will go on. the court, I'm reading from the judgment now. It is the contention of the appellants that the minister was biased in issuing the ATP as the authority to proceed because A, she was on the same platform as the president, vice president, and others during the 2025 election campaign when they made repeated public statements depicting the appellants, particularly Azzuddin Mohammed, as criminals, tax frauds, and as being guilty of offenses subject of extradition request in the context of A. Azzuddin Mohammed being a political rival. B. The minister herself, through her body language and remark, was derogatory regarding Azzuddin Mohammed at one of the elections meetings. This is what the court is summarizing their arguments. And C. She sought, the minister sought and accepted advice from the Attorney General, who also attacked Azzuddin Mohammed during the election period and on his online program, thereby exposing his bias against Azzuddin Mohammed. That is their contention in the Court of Appeal, according to the court documents itself. This is what the court is summarizing their submissions to be. So they have even included this program in their submissions, saying that I have used this platform, this online platform, to attack Azzuddin Mohammed, and that I have used the political platform to attack him during the elections campaign. As regards Nazar Mohammed, it is claimed that apart from being Azzuddin Mohammed's father, he is a supporter and sponsor of the Azzuddin Mohammed's political party, and therefore the bias against Azzuddin Mohammed affects him as well. That's their contention in the court. Then the court then traces the history of the appeal and spoke about how the matter started in the High Court and the arguments were heard before the Chief Justice, and the Chief Justice ruled that a case of bias was not made out, and the Chief Justice dismissed their case. And they have filed this appeal now to the Court of Appeal. So the court gave a historical recitation of the case. And then the court listed a number of grounds upon which the Mohammeds based their appeals. And it is not, I don't think it is necessary to deal with all the grounds. But let me read them quickly for you so that you get a complete picture. The notice of appeal sets out grounds that run from A to N, letters A to N. We do not propose, the court does not propose to address each in turn, as it was agreed at the hearing of the appeal that the focus was essentially on the following issues. One, whether the rule against bias applies at all to the minister's decision to issue an ATP under Section 12 of the Fugitive Offenders Act, having regard to the circumstances of this case. Two, whether having regard to Section 27 of the Interpretation of General Clauses Act and a principle called the Cartona Principle, was there any requirement to delegate? For the minister to delegate the statutory functions conferred under the Fugitive Offenders Act and for advice in relation to the Fugitive Offenders Act to be given by a delegate other than the Attorney General. So that is how the court summarized the issues. Whether the minister should have delegated her function and whether the legal advice that the Attorney General gave should also have been delegated to someone else, and of course, whether the minister was affected by bias in issuing the ATP. The court examined the issue and the court found that, and I'm going to read, While the appellants submitted that the minister is not entitled to take a cursory look at the document, but must make a real evaluation of matters such as whether they are extraditable offenses, double criminality, political or other prosecution, settled in Section 8 of the Act, there is no evidence that the minister did not do what was required under the Act. Indeed, for an avoidance of doubt, there is no challenge to the ATP itself. Remember, I keep saying that they have not alleged that the minister breached the Act in any way, shape, or form, or that the minister acted contrary to any law. All they are saying is that the minister is biased. And that is what the court is saying. They have produced no evidence to show that the minister did not comply with the provisions of the Act, or violated any provisions of the Act, or violated any provisions of any law. As contended for the appellants in the speaking notes, this is in essence a challenge to the qualification and standing of the minister to make this decision because of her bias or apparent bias. So they are saying that because of this alleged bias or apparent bias, that is all they're complaining about the minister. And because of this bias, she is automatically disqualified and her decision is automatically defective. The court holds that in the context of the Fugitive Offenders Act, in deciding whether to issue an ATP, the minister exercised an administrative function, more so that there is no need for the subject of the request to be heard in relation to whether an ATP should be issued or not. The court upheld our submission that the act that the minister is performing is simply to trigger the extradition process. She's not determining any legal issues. That is what the magistrate, the High Court, and the Court of Appeal have to determine. The magistrate is just signing a form saying that I'm satisfied that I've received this request, and the request is good, and the request complies with the statute or the legal provisions in the law, and magistrate, you can go now and begin the process of determining the legal issues. A minister exercising that function is not a judge. Bias doesn't apply. A minister can be biased and exercise those functions. That is what the court is saying. And that is what we said. Even if the minister was biased, that bias does not transcend or translate into affecting her functions. This is not a case of the minister having to make a decision between two competing parties or competing positions once the statutory provisions have been met. The minister don't have to make a choice here. Once the law has been satisfied, once the request is valid, and it complies with the law, the minister has no discretion. She must issue the authority. So the minister is not deciding anything. She don't have to choose between one or two options. That is what the court is saying. It is in those cases where a discretion has to be exercised that one can claim bias. Here it is these facts do not lend to that interpretation. In fact, the court found that it would have been a dereliction of duty in the minister to consider an extraneous matter in relation to what or what might not have been said during the election campaign, or whether or not to issue the ATP. In fact, the court is saying that look, if the minister had even addressed her mind to what transpired in the election and what happened in the election and who said what, then the minister would have acted wrongly. Because when that ATP comes, it has nothing to do with politics. It has nothing to do with what was said in an election campaign. This is whether you should be extradited to stand trial in the United States of America, not here. And that is how the court approached it. The Fugitive Offenders Act does not provide for the minister to consider any other issue. That's what the court said. Similarly, the evidence is that the AG gave advice on points of law. They have been complaining bitterly about the AG. They said that the AG is biased against them. The AG said things on this program that makes him biased. The AG said things about on the elections platform. Yes, the AG did all of those things. But the AG is advising on law. And the law of extradition of Guyana does not change, depending on who the subject of the extradition is. If I am going to advise whether this is a glass or not, the character of this that I have in my hand will not change if the advice is going to Mary Jane, and then change if the advice is in relation to Tom Jones. It is a glass, it is a glass. So when I give my advice to the minister or to the government of Guyana in relation to any given matter, in relation to law, I am advising on the law. My advice on the law will not change because of the content of the character of the person to whom the advice relates. The law doesn't change depending on whether it's a politician or a non-politician. And that is the type of ridiculous argument that was being advanced. And this is what the court said. The submission in the speaking notes, they submitted speaking notes, for the appellant is that the decision of the minister was heavily influenced by the admitted legal support provided to her by the Attorney General in terms of case law and the Fugitive Offenders Act. They are saying that the decision of the minister was heavily influenced by the advice that I give, and that my advice is biased because of politics. The court said to say that this contention is preposterous is to be generous. To say that this contention is preposterous is to be generous. That's the court saying. That about their submission. I said it over and over again. These submissions are not worthy to be made in a court of law. And that's what the court is telling them. To say that this contention is preposterous is to be generous. Keep that as a quote for me, please. They continue to say, the fact is that the AG is the principal legal advisor to the government. It cannot be that the advice in terms of applicable case law and on an uncomplicated statutory form can be biased. That is what the court is saying. That's what I said. My advice can't be biased if I'm to interpret what a case says. If I'm to read the case of King and the Director of Public Prosecutions, or Dataram and the Director of Public Prosecutions, and I'm to advise on what those cases say, would my advice be biased because the person who is affected is a politician, or is a Hindu, or a Muslim? The principles in the case will change. And they said I assisted the the minister in filling out the ATP. The ATP is a form that is at the back of the act. They say, I am biased in my filling up of the form. The court said that it is preposterous to say that the advice of the AG on applicable case law and on an uncomplicated statutory form can be biased. There is no evidence to support a finding that such advice could be tainted with bias. Intermingling with bias, bias simply does not arise. I'm reading verbatim from the document. And then the court went on to deal with what the law of bias says. And dealt at length. I can't go through all the areas. I'm just highlighting a couple of things for you. The court also adopted our submission to say that they're saying that the thing should be delegated to a minister, another minister. But whichever minister it was delegated to, their contention is that the entire government is biased. So that minister would be biased too. The court made a finding of that as well. The court said, I want to read the part. Oh, they said that the AG should have delegated his function as well. But to whom can the AG delegate the function? They have not identified anybody, and the court found that submission to be without any merit whatsoever. The court found as a matter of conclusion that the minister does not start the extradition process, the requesting state does. The fact that the statements were made on an election platform does not translate into bias. The minister has no interest in the outcome of the case. The United States, as the requesting state, does. We have no interest in this case. It's the United States government that has an interest. And that's what the court is finding here. I'm trying to get to the point where they said the point that I keep making all the time about if every time an extradition request comes, all one has to do is to jump into the political arena, and then you will have the untenable situation where you can't extradite. The court accepted that submission here. I'm trying to find it, but I'm not finding it right now. Hold on, give me 1 second. And nobody can come. Nobody, they love to complain that I'm discussing the matter. But this is the judgment of the court. The case is finished, and the judgment is a public document. It's all over the internet, so any one of you can go and read it. Anyway, I can't seem to find the particular statement that I wanted. But the court dismissed the appeal, holding that the appeal has absolutely no merit. Let me repeat that. The court dismissed the appeal, on the ground that the appeal has absolutely no merit. The appeal is dismissed with costs to the Minister of Home Affairs in the sum of 1.5 million and cost to the Attorney General in the sum of 1.5 million. That's $3 million in costs, which of course we intend to pursue and receive payment of. You will recall that in the High Court, on the 4th of February 2026, the Honorable Chief Justice Navindra Singh awarded costs against them again in the sum of $500,000 to the Attorney General, $500,000 to Minister Waldron, and $500,000 to Judy Latchman, the magistrate. So in total, you have $3 and $4.5 million in costs already awarded by the court, and not a dollar has been paid. I wrote a letter to Roysdale Ford dated the 11th of March 2026, in which I pointed out to him that the cost order made by the learned Chief Justice stated or states that the costs should be paid by the 27th of February 2026, and that as of the 11th of March, we did not receive any payment as per the order of the court. I requested payment to be made forthwith. We have not received a response from this letter. I said in the letter that if payment is not received, the necessary steps will be taken to enforce the order. So steps will soon be taken to enforce the order of Chief Justice Singh in the sum of 1.5, well, at least 1 million for AG and Minister of Home Affairs. The magistrate has her own lawyer, and that's another 500,000. And also a letter will be dispatched tomorrow for the payment of 3 million costs awarded by the Court of Appeal. So I thought that I would spend some time in going through this judgment with you so that you understand the nature of the submissions that are being canvassed in these courts, the quality of the submissions, and the way that they have been rejected one after the other by different courts. And unfortunately, we still have the matter in the magistrate's court, and in my view, the matter is languishing there, unfortunately and unnecessarily. The last 3 days, you heard, as I said at the beginning of the program, time being spent, energy being spent, judicial resources being spent on trying to establish that this request did not come from America, that the documents were somehow manufactured somewhere at Home Affairs or Foreign Affairs Ministry. Ridiculous contentions when the Court of Appeal, the High Court have said that the request came. They have said in their documents to the court on the oath that they are challenging a decision, an extradition process emanating from a request that came from the United States of America to the government of Guyana. They have said that 10, 15 times on the oath. But that is what you see going on in the magistrate's court. But the least said there, perhaps, is better. This is an important month, the month of March, from the perspective of the People's Progressive Party, is the month dedicated to the celebration of the legacies of Dr. Cherry Jagan and Janet Jagan, two of the greatest human beings to have graced this country and the politics of this country. Comrade Janet Jagan was not born here, but spent most of her life here. 80% of her life was spent in Guyana. Dr. Cherry Jagan, of course, was born on plantation Port Morant on the Quarantine Coast. These two persons led the struggle against colonialism, led the struggle for independence, and then had to fight after independence for 28 years to win that freedom that we thought we won when we got independence, but which freedom was taken from us by the Barnum-led PNC and then Desmond Hoyt. That freedom that I speak about is the freedom to vote and all the attendant freedoms that are attached to that fundamental freedom. Once they take away your right to vote, they take away all your other freedoms. That's the central one, because they will have to take away your right to criticize, they will have to take away your right to protest, they will have to take away your right to express yourself. That is how dictatorship can survive. If they don't take away these various important rights, then they can't survive. These rights are the antithesis of dictatorship. So once you have a dictatorial government, they will begin to take away all those rights for them to survive. Because if you're able to criticize, if you're able to challenge them in the courts, if you're able to march, if you're able to protest, if you're able to write, if you're able to express yourself, they cannot survive in government. And for 28 years, Janet and Cherry Jagan led a movement that involved other people too, and other groups, but they led from the front, and they were able to restore democracy in this country by free and fair elections returning on October the 5th, 1992. And we are celebrating their lives during this great month of March, as both of them died during this month of March. Of course, on the 29th, the People's Progressive Party will have its mega event at Babu Jan, as we do annually, where the president and the general secretary of our party and other leaders will speak, as we normally do. But as I am on the lives of the Jagans, and I began by saluting their struggle and the sacrifices that they have made for our freedom and the freedoms that we enjoy today, we must never take these freedoms for granted. Today, as our Muslim brothers and sisters are observing the holy month of Ramadan, our Christian brothers and sisters just completed observing Lent. Our Hindu brothers and sisters just celebrated Holi. Our Hindu community will move into Navratri observances from Thursday coming for 9 consecutive nights. Our Christian brothers and sisters will move into preparation to celebrate Easter. Our Muslim brothers and sisters will be celebrating Eid sometime over the next few days. And here it is, you have a kaleidoscope of religious observances, festivals and festivities being celebrated, being observed, and being participated in by the individual religious groupings as well as at a national level. We have Holi as a national holiday. We'll have Easter soon, and that is a national holiday. We are observing the month of Ramadan, and we are observing it together. These commingling of religious activities, religious observances, and religious festivals and festivities that are occurring almost simultaneously in some cases and contemporaneously in others, are being done in peace, in dignity, in unity, in love, in camaraderie, in brotherhood, and with seamless ease. And we must never take this state of affairs for granted. It was not always like this. Janet and Cherry Jagan fought for these rights and freedoms. Others fought, some died in the process of fighting. Many died. Many lost their liberty. Many lost their limbs. Many suffered. Many sacrificed so that we can enjoy this admixture of culture, religion, and religious freedoms that we are currently enjoying. Pause for a moment and look around the world. There are many places on planet Earth now as I speak where wars are being fought. Children, women, and men are dying. Families are dying. People are losing their limbs. Buildings are being bombed. Countries are being invaded in the name of religion or because of religious-based hostilities and issues. And that has been the position around the globe for centuries. We in Guyana are enjoying an exceptional atmosphere of national unity, national fervor, and a multicultural explosion of religion and other ethnic events taking place at the same time. And we must celebrate that. But most importantly, we have to work hard to protect these cherished rights and freedoms that we enjoy. We must never take them for granted. Others are dying for it. I say so. And we must stand up when we see the ugly head of division, when we see the destructive hand of division being raised. And I've seen that recently in our religious communities. I have seen our political leaders being denigrated or denigrated, disrespected, attacked because they are attending religious places of worship. That must be stopped, and that is a new phenomenon. I have been in public life now for nearly 3 decades. I am not new to this thing. While there are others who are far more experienced than I am getting there. I have been going to the mandirs all my life. I have been going to churches across this country all my life. I have been going to mosques in this country all my life. I was married into a Muslim family for over nearly 20 years. Religious Muslim family for over 20 years. And yesterday I went to a mosque in Le Souvenir, and there was an outpouring of hate and criticism against me on my Facebook page. And I know where it is coming from. These things never used to happen before in this country. It is since the birth of one political movement. And they have a robot farm. They have 6,000 profiles, fake profiles that they manipulate and they unleash on you. And it's sheer hate. They preach violence. I want my operator to put up a post, and this is one of their accounts, constantly criticizing me. It says there that the name of it is Abu Dhabi. It's a fake account, obviously, run by the people whom I've identified. And here that post is saying, read it, it's on the screen, operator, they can see it. You will see that Abu Dhabi is calling on me to be stoned to death because I am attending a mosque. That is the level of religious intolerance that these people are preaching, and the level of political intolerance that they are practicing. When I say that these people are not good for the future of this country, that is what I'm speaking about. It's not about political rivalry. It's about a class and a breed of people that we have never seen before, whose onslaught and assault is of a different type. I call upon every single Guyanese to condemn that level of religious intolerance. Those things are taking place in countries where people are dying in the name of religion. And that is what they are posting religiously against non-Muslims for going to the mosques. Muslims go to the mandirs, Christians go to the mandirs, Hindus goes to the churches. I have always done that. We in the People's Progressive Party have always done that. These things are not new. I see postings and comments that we are going and doing this and I am going to the mosque because of this person. I have been going to the mosques of this country for decades. I've been going to all the religious places of worship in this country for decades. And you can go through my Facebook page. But it is the religious intolerance that I am condemning in the strongest possible fashion, and I invite you to do so. We must not allow, in any form or fashion, that type of insularity, danger, and divisiveness to enter into this peace and tranquil environment that we enjoy as a unified people of 6 different origin, culture, and ethnicity. The Constitution of our country guarantees freedom of expression, freedom of religion, freedom of culture, freedom of dress as fundamental rights and freedoms. And we have to protect it as a collective. Today is going to be me. Tomorrow, when a Muslim appears in a Hindu mandir for Navratri, a Hindu and misinformed Hindu can reply and respond in that horrible manner. I'm not encouraging that, but I'm just telling you how these things happen. And they lead to tribal wars in countries. They have led to tribal wars and religious wars in countries across the globe. And there seemed to be an attempt to introduce that into our beautiful country. And it is the responsibility of all of us to stamp it out, and stamp it out resolutely, and urgently and strongly. And that is my urge tonight. Religious intolerance must never, ever, no type of intolerance must be encouraged or countenanced by us. Before I go, I didn't get an opportunity to speak on the closure of Stabrook News. Stabrook News has played a role, a significant role, in the restoration of democracy. It has played a role in offering a voice and for bringing an outlet at a time in our country when we were reeling under the consequences of a dictatorship that was entering its third decade. Stabrook News, the PPP, the then Guyana Human Rights Association, the WPA, the Working People's Alliance, Paul Tennessee and the Democratic Labour Movement, the PCD, GAU, the NASI, religious organizations, they all played a role. They all played a role in helping us to break the back of that dictatorship. Stabrook News played a role and has played a role ever since. I don't agree with many things that Stabrook News have written. I don't agree in recent times in particular. The approach that Stabrook News has adopted on many, many issues, involving issues regarding myself, not personally, but publicly and officially. But I still believe that Stabrook News has played a significant role, and the closure of Stabrook News would cause us immeasurable loss as a society. Stabrook News has columnists that I don't agree with. Some of them I never read. I've never read this diaspora column that keep writing every week. I don't agree with many, many of the columns, and Stabrook News has had its class bias over the years. All of that I know. But I'm saying that Guyana would be poorer without Stabrook News, and I want to salute Stabrook News for the contributions that it has made over the years. I think it has played its part. Many may argue that it outlived its usefulness, but it played its part, and Stabrook News would have continued, I think, to play an important role in this country. But with the evolution of society, with the development of technology, things are changing. Businesses are closing, more new businesses are being opened. That is the nature of the world. Mankind seems to be on a haste to put mankind out of relevance. But as a topic for a different time and a different place. I want to thank you very much for being with me over the past hour or so. This is my program after I wasn't here for a while. So I want to thank you very much. Please enjoy the rest of this week. Now, Ratri, greetings to my Hindu brothers and sisters. I'll be in the mandir as I will be in the mosques. Tomorrow I'm going back into the mosque to show those who think that they can discourage me. I'm going to be in the mosque, and before the end of this weekend, I'll be in the mandirs. And when possible, I'll be in the church for Easter as well, because that is how we do it in the People's Progressive Party, and that is how we do it in government under the banner coined by President Ali, One Guyana. We will work every day to ensure that we deliver on that national ethos. Thank you very much, and may God bless you, and continue to be safe.